Hot mic.
Yeah, you can hear me all right?
Yeah, I can hear you great on my device, so
Okay.
hopefully everybody else can too. And I will do my best to monitor the questions that get put in the chat, just because I'm on the mobile. This is not
Yeah,
as
I
is
can see
good,
him
you know.
too. I've got two screens, so I can, well, that's why I'm looking over here rather than here right now. So I've got you over on that side.
Perfect. And do we have people that are filtered in already?
Yeah, it looks like there's 6 attendees right now.
Okay, great. So I think it looks like it is 12:01. Do you think that's good? We can go ahead and do the introduction and get underway.
Yeah, I think that that's fine. People might show up a little late, but that's fine. Oh, we only have 5 attendees now, but okay.
All right. Well, good afternoon, everybody. Thank you for joining us here. My name is Daniel O'Neill. I'm a partner at Thompson Co. I help run the CLE committee for the Houston Young Lawyers Foundation. So everybody is in for a treat today. We have a fantastic presentation from somebody that y'all have seen before if you have been as a part of the HYLA or HYLF committee a community. Evan Lange has presented several CLEs for us over the years. This one in particular, it's a hot button topic right now. Everybody's talking about it. Everybody's very interested in it. So we're really looking forward to it. I've known Evan for a number of years pre-pandemic, so to me that seems like a very very long time at this point. We're both fellow SMU grads. Evan runs his own firm. I think of him primarily as a plaintiff side labor and employment lawyer, but he also does a ton of other stuff, including estate planning, probate, and in his plaintiff side labor and employment practice, he's taken on numerous Fortune 500 companies. He never backs down from a fight. He loves representing the underdog. He is a great guy to know. So, Evan, thank you so much for agreeing to present this topic for us. I'll go ahead and turn this over to you now. Thank you again.
Thanks for the introduction. That pretty much covers, yeah, that covers a lot of it. I've been doing labor and employment for about 10 years now, not for, and it's almost 10 years to the dot. And I represent the vast majority of the people I represent are employees. So this CLE is geared towards really an audience of those who are curious about disability rights in the workplace, and then also what happens when somebody's injured in personal injury. Um, Maybe it's an accident or whatever it may be, but in a personal injury setting, because there's a lot of PI lawyers who need to know what their clients' rights are in the workplace, especially if they can't um, go back to work immediately while they're going under treatment. But this also applies to most disability related cases as well. So, and this goes for injuries that are either on or off the job. It doesn't have to be on the job. Okay. All right, so the basic law in Texas for employment law is employment at will, which means that if there's not a specific contractual provision, then everybody is falls into this bucket where the employer can terminate you for a good reason, a bad reason, no reason, made up reason, unethical reason, unfair reason, you name it, they can do it. Now, there are reasons that can't be. There are illegal motivations to get rid of somebody, such as somebody's age, race, national origin, disability, sex, veteran status, pregnancy, gender identity, sexual orientation, religion. All those are protected statuses. But if the motivation is not one of those things, then primarily the employer can do what they see fit with the employee. So there's four main laws that protect injured workers. The first one, the major, probably the biggest one, is the Americans with Disabilities Act, and then the second biggest one is probably the Family Medical Leave Act. Then there's Chapter 21 of the Texas Labor Code, and then there's Section 451 of the Texas Labor Code. And I'll go into each one in probably too much detail. So first, let's talk about what employers these laws apply to. The Americans with Disabilities Act and Chapter 21 of the Texas Labor Code, also known as the TCHRA, the Texas Commission on Human Rights Act, those apply to employers with 15 or more employees. Any fewer, and the law doesn't impose the ADA requirements on the employer. There are other scenarios where you could have under 15 employees, such as sexual harassment or race discrimination. But insofar as disability issues go, it's that 15 employee threshold. And then for the Family Medical Leave Act, you have to have 50 employees within 75 miles of the employee's workplace. And the employee, to be a covered employee, needs to have worked essentially full time for an entire year before it happens. And then Section 451 applies to all employers. In my opinion, I'll get into more about where there's a debate on that. But this is the size of the employers that are covered. So if you have somebody who works for a large company, these laws will take effect. If you have a client or you know somebody who's been injured or hurt or otherwise disabled, then and it's a smaller employer, then the law may not protect them. Um, What is a disability? Under the ADA in Chapter 21, I'm just going to say ADA. Just know that the ADA and Chapter 21 mimic each other. They have the same wording and the same application. One is just federal law, one is state law. And you might sue under state law rather than federal law for preferable venue, which I think I talk about later. But a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. And this is broadly interpreted. I had a coworker who said it covers a broken leg and a broken heart. And that's the truth. And they amended this law in 2008 to be broadly interpreted because the judges were interpreting it very narrowly. And you had like one case, I think, out of Eastland where um, some person had a amputated leg, and they said, well, that wasn't a disability. So in '08, Congress went and amended the law to make it broader. Um, so yes, it does include physical disabilities or mental and emotional disabilities. So if you have somebody who gets in a car crash that has PTSD now, that can be a disability that would need to be accommodated under the law as well. But some other examples of major life activities: walking, seeing, hearing, speaking, lifting, standing, and concentrating. So it's very broad. Um, the requirements and prohibitions under the ADA are on this slide. So under the ADA, you can't make an adverse employment decision based on someone's disability. That's disability discrimination. That's saying I'm going to fire this person because they have narcolepsy or epilepsy or PTSD or something like that, or they can't walk or need a wheelchair. And then you can't retaliate against somebody for trying to get to their rights under this law, which I'll talk about in the next part of the slide. But you can't say I'm going to fire this person or demote them or cut their hours because they were seeking an accommodation or actually obtain an accommodation. So the two parts of the cannot are you cannot discriminate and cannot retaliate. The must do part is to give somebody a reasonable accommodation. Now, there's no set definition of what a reasonable accommodation is. It can't impose an undue hardship on the employer. Um, and then, in order to settle on what a reasonable accommodation is, there has to be this interactive process. So, when an employer finds out that somebody has a disability, or the employee comes to them and says, "Hey, I need an accommodation," there's this loosely defined back and forth process. It's really quite loosely defined at law, but it's got to be some sort of discussion, and it can be an affirmative burden on the employer when they become knowledgeable of the employee's disability, and they need to work together to try to figure out what can help the employee get the job done. And if they don't, then you can end up suing them for a third claim under the ADA, which is failing to accommodate the employee. Um, yeah, I think this is on the next slide. Um, so the EEOC is involved with employment discrimination cases for the most part. There are some that fall outside of the EEOC, such as race discrimination under the Rights Act of 1866. Um, but Title VII of the Civil Rights Act and the ADA require you to go to the Equal Employment Opportunity Commission. If you skip this step, then you're going to lose your case on summary judgment because you failed to exhaust the administrative remedies. So you file your charge with the EEOC. The EEOC will do an investigation, which is usually asking the employer to respond to the charge in writing, in what's called a position statement. They'll do their investigation. The EEOC may find cause, which is saying that the employer did something wrong, or they can issue the right to sue, which is not necessarily saying the employer was right. It usually means that they just couldn't get to the investigation. And in 10 years, I've never had a cause finding, and it's not because they didn't have valid cases. It's just they have such limited resources and they will only take on um, usually cases that affect a large amount of people, like somebody like women getting paid pennies on the dollar at a, Fortune 500 massive company. Is something that they can truly make right for a lot of people. But if they do find cause, then like I said, the EEOC can join in on that lawsuit if they will, and then that's a kind of a disaster for the employer if you end up getting sued by by the EEOC because then they get to determine the terms upon which the case gets to settle. The limitations of the ADA are the employee must be able to do the essential functions of the job with or without a reasonable accommodation. So I use the example that if you have somebody who needs two legs to do a job and they have an amputation, there's no reasonable accommodation that can do that. Or if you need a job that needs binocular vision, right? You have a pilot and they lose their right eye. You're not ever going to have there's no accommodation you could give a pilot who's missing an eye. So in that instance, it probably would be okay to terminate that employee. But if the employee can do the job with a reasonable accommodation, then you need to do that. Otherwise, you end up in the discrimination and failure to reasonably accommodate and potentially retaliation claims if the employee has sought um, to exercise their rights under the law. Um, so that's here on the left. In the middle was what I was just talking about. And examples of reasonable accommodations can be light duty, time off, modified schedule, workplace equipment, such as like ergonomic keyboard, wheelchair, or even remote work. Is that something that I've seen since COVID, where before COVID, the employers were rarely obliged to provide remote work as a reasonable accommodation because they would just say we can't do it. And after COVID, it's very difficult for an employer to say they can't do remote work. It's too unduly burdensome because we all basically work from home for an entire year, so it's usually not a good excuse. Unless there's something that really physically requires the employee to be present. So light duty, that could be desk work for a certain amount of time, like in order for a bone to heal. Time off, that can go up to usually about the 12 weeks that I'll talk about under the FMLA. A modified schedule. Somebody has narcolepsy, they may need a different schedule. And I've talked about the other two examples already. So the difference between the ADA and Chapter 21 of the Texas Labor Code, no, there's no substantive difference in the law. There are different statutes of limitations. So the way employment law works, which is really crummy, is that the facts that you're going to sue over have to be investigated by the administrative agency, which can be the Texas Workforce Commission, the state agency, or the Equal Employment Opportunity Commission, the federal agency. And so, under the state law, the facts can be looked back for 180 days, and then under federal, it's 300 days. So, if somebody comes to you on the 301st day of them after they were fired, and they said, "Hey, we don't want somebody who needs an ergonomic keyboard here. Yeah, it's just too much to ask, and you're fired." On day 301, that can't be investigated, and then they're completely up the creek. And then under state law, so when they issue that right to sue, you cannot sue until you have that letter that states you may sue the employer, which is the right to sue. 60 days to file that lawsuit and serve the employer. There's case law, bad case law on people who don't serve the employer within the 60 days. And 90 days to file the claim under federal law. And you might wonder why that you would pursue a claim one versus the other, and you can get a more favorable venue in state court. Like if I can get an employer in Harris County, right? If it's a domestic employer and the state law claims it's not been 180 days since the facts came and went, and I can keep them in Harris County or Dallas County, or Bear or Travis County, then that adds value to the case. Um, and then the ADA has preemption issues. If you try to sue a state employer under the ADA, you may run into the 11th Amendment, which is extremely problematic, extremely problematic if they're immune to being sued under the law. Now I'll switch to talking about the Family Medical Leave Act. So what it is it's an entitlement. It is an entitlement to 12 weeks of unpaid leave. Some states, like Colorado, have paid family leave. Um, we don't. We don't do that. And it's just not required, and it doesn't look like that's going to be anything that happens anytime soon. It can be used to take care of somebody with a serious health condition, adoption, and birth of a new child as well. There's some other reasons, but it's for the purpose of this presentation, serious health condition. Um, uh, you can take it to take care of yourself or a spouse or a child. Um, I would have to look up to see how far that goes out, but I think it even goes to taking care of a parent. Um, but you actually have to be the one giving the care. You can't just say, "Oh, my kid's hurt. I'm going to take time off." Like you have to be the active caregiver. You can take it all at once or you can take it intermittently. So importantly here is that if you have somebody who's gotten in a car wreck and they need treatment, they have to go to the chiropractor, physical therapist, 3 times a week. They don't necessarily need the full day off work. Um, but sorry, I got a cat here. Um, but they don't need the full day off work. They can take that intermittently. They don't have to take all 12 weeks at once. You can take Monday off. You could take a couple hours off, even under the Family Medical Leave Act. Health insurance continues, but the employee will probably have to pay the premium out of pocket. And the 12 weeks, so if the employer doesn't have 50 employees within the 75 miles, you can still get leave under the ADA. Leave is a reasonable accommodation. How long an accommodation of leave would be is less clear. Courts kind of cut it off after the 12 weeks. They use the FMLA as an example, but and it's not an entitlement under the ADA. The employer does decide what the kind of accommodation is, and if they decide light duty is better than leave, then you're kind of stuck with that. But FMLA, 12 weeks worth of unpaid leave. not unpaid, not paid. Serious health condition can be for yourself or spouse or child. So this can apply to your client, your PI client, or it can be the spouse of your PI client. And you can take it all at once or intermittently. Uh, so the protections of FMLA and the things that the employer can get sued about under the FMLA, you can't interfere from the employee getting that entitlement to leave, assuming that they are eligible. Interference is something you can sue someone over. It's actually like a really fun thing to sue somebody over because if they're entitled to it, it's like strict liability. If they were entitled to it and you stop them from getting it, like you're going to be in trouble under the law. And You can interfere by stopping them from getting it. You can also interfere by asking the employee to work while they're on leave, which is why sometimes people will call me and say, "Oh my gosh, like I'm on FMLA and they lock me out of my computer." And the reason for that is they don't want you doing work. They can get in trouble for you doing work. And it's not a retaliatory thing. It's like mandatory. Um, you can't retaliate against somebody for seeking or taking the leave. That would render the law pointless if you were able to retaliate against somebody for taking the leave. It does happen. A lot of cases that I see are disability related cases because the employers just feel that if you can't do the job or you need the time off, like why am I retaining you? Let me get rid of you. But that's not the case. You can't retaliate against someone and then return to job when somebody comes back, whether it's from that serious injury or the pregnancy or whatever, or paternity leave, whatever that may be, they need to be returned to the same or equivalent job. It has to be there. The same goes for veterans leave as well. But yeah, when you return to the job, that job needs to be there or some substantially similar job at the company. Um, FMLA is a funny law. The courts will let the employer, especially in the Fifth Circuit, will let the employer wiggle out of stuff very easily. So there are notice requirements for the FMLA that you really need to follow in order to put the employer on notice, and there's paperwork that has to be generated, and you have to give them. There's notice requirements for sure, to say the least. They will ask for medical information and a doctor's certification that you do need to leave. Under the ADA and the FMLA, the employer usually is allowed to get your protected health information to figure out what's going on. A lot of people call me and are like, I don't want to give them my, whatever it is. And I'm like, well, you're the one that's asking for the accommodation. They need to know. So you gotta you gotta work with them. How do they know? How could they possibly know what's a reasonable accommodation if you don't tell them what's wrong with you? Um, Under the FMLA, you'll need that return to work paperwork. Employers can have it run concurrently with your paid time off, your vacation, short-term disability. So some people say, "Oh, well, I have 3 weeks of vacation and then 12 weeks of FMLA. I want the 15 weeks." Like, no, they can tell you 12 weeks of FMLA and you're going to eat up your vacation time during the first 3 weeks. But those would be paid. Those would be paid weeks of leave. And it's 12 weeks per year, not per injury. When your time expires, if you can't go back to work, don't go back to work. It's job abandonment, and then they can fire you for they can fire you usually without concerns about legal issues. Um, I talked about this a little bit earlier. If that employer is large enough to be covered by the ADA and Chapter 21, then you could still get leave as a reasonable accommodation. That case law um, does support maybe up to 12 weeks, but reasonable accommodations are looked on that case by case basis. And what is reasonable is the choice of the employer. So it may be hard for you to get leave just under the ADA. On the job injuries, so these laws apply whether or not the injury was on the job or not. If somebody's, driving down the Beltway and gets hit, breaks their whatever, that applies. If somebody's lifting heavy boxes at work and tears a rotator cuff, that's also going to apply under these laws. But for on-the-job injuries, Section 451 is specific to workers' compensation. It is the prohibition of retaliating or discriminating against somebody for pursuing workers' compensation rights. I was arguing with ChatGPT about this. They were like, no, it only applies to covered employers, and I really disagree with that. I think that if an employee does or doesn't know whether or not the employer is covered, doesn't really matter. Whether or not the employer is covered or not doesn't really matter to me either. The idea is that seeking the leave is what's protected, and that should be protect you from retribution, from unlawful retribution in the workplace. So the law states an employer cannot discharge or discriminate an employee because the employee filed a workers' compensation claim in good faith, hired a lawyer for that claim, instituted a workers' comp proceeding, or testified in one. Um, again, the law is broader than that. They can say, "Hey, I think I need workers' comp." And that can be enough. Just same thing goes for, hey, I need an accommodation, or hey, I need family medical leave. That can happen. And yes, because the whole public policy of the law is to protect the workers from punishment by trying to get their rights. Um, this is a weird little law that can't be maintained in federal court, so it does often bifurcate the case, and just in federal courts will refuse to hear it, just like they'll refuse to hear probate matters or divorce. They won't hear workers' comp claims, even if it's a retaliation claim. And employment law is not workers' compensation law. Those are separate branches of law, but this specific retaliation, discrimination under 451 is employment law, if that's not muddy enough. Um, in order to prevail on a 451 claim that engage in that protected activity, I think it's broader than what ChatGPT was arguing with me about. The adverse employment action, right? Demotion, termination, reduction in hours, discrimination, on the terms and condition of employment. That adverse employment action is going to apply to all these laws, right? It's not just wrongful termination that is protected under these laws. It's that demotion, reduction in hours, failure to hire, failure to promote. Um, Sometimes a different schedule. The law is really bad on schedules, but an unfavorable transfer, right? If they decide to transfer you to Vladivostok, then that can also be an adverse employment action. Sometimes discipline can be an adverse employment action. Sometimes it can't. You'd have to look pretty careful at that. And then the cause of the adverse action is the protected action. So protected activity, negative activity, cause, and that goes for retaliation under all of these statutes. The damages that you get would be lost wages, lost benefits, and other harm caused. Maybe you might be able to get punitives. I believe it applies to non-subscribers. It just requires that the employee make that claim in good faith, not it's absent to whether or not the employer actually has the insurance. And the bottom one again states that it's not really up to the employee to know, and the employer may not have insurance and still just not like that the person asked and retaliate or discriminate. So that's what happens. Statute of limitations. FMLA, 2 years, 3 years for willful violations. The ADA, 300 days from when the employee knew that the discrimination was coming and retaliation was occurring. Um, Labor Code, 180 days from when they knew and was occurring. So this was a case about some pilots that like knew that there was this forced retirement coming down the pipeline, and they waited till they were actually forced out to file the claim. And then the problem was that the judges were like, no, no, you knew when they instituted this policy that you were going to be forced out. So that was when you were on notice that you were getting discriminated against, and that started the clock, not the actual termination. So. this is the kind of hostile environment that I um, have to deal with. The Texas Labor Code, that one is 2 years. Damages. This is a particularly depressing slide. So under the ADA and the TCHRA or Chapter 21, you get actual damages, which is lost wages, lost paycheck. Somebody gets fired, they're not earning any money. That's going to be your damages. Although on all of these, the actual damages, your unemployment benefits will count against as mitigated damage. You can get punitive and compensatory damages for the ADA and TCHRA. Um, it's has layers based off of how many employees there are. So from like 15 to 100 is 50,000 max. And then if it's 500 plus employees, then it's 300,000 max. If you get more, the judge is gonna, comply with the law and reduce the verdict to what it is, um, to the cap under law. So it's a very similar damage model to MedMal, where you have actual damages and then the limits on the punitives. Um, which is uniquely terrible when you have somebody who works for a very small company who's been sexually harassed or even assaulted in the workplace, and you have to have a conversation with them that um, sometimes at law that assault may be considered sexual harassment, and then your emotional damages for that could be limited to $50,000, which is insane. Um, Mandatory attorney's fees, that applies to all three of these laws. So in civil rights laws, you are going to get attorney's fees, and the logic behind that is it shouldn't be only people who can afford an attorney to have civil rights. The FMLA is more fun because it's more of a strict liability, right? There was this entitlement. Everybody, the employer was covered, the employee was covered. There's an entitlement. They took it or were not able to take it, and they were retaliated against. And so you get actual damages, and then you can get liquidated damages, which is the twice the amount of actual damages, and the mandatory attorney's fees. 451 actual damages, punitive and compensatory, and mandatory attorney's fees. Um, the bad part about actual damages is that it is lost wages, and what happens is that when somebody gets fired, they have to find another job. The law does actually require you to mitigate by looking at for another job, but everybody usually goes searching for another job because you need a job. And then the EEOC process takes that 6 months to do roughly. They want to hold on to that case for 6 months for cooling off period. And by that time you end up having this case where the person has, let's just say the person made $100,000 a year. They were out of work for 6 months. And then their actual damages are, $50,000. And then you have the defense attorneys who are betting that you won't actually sue them over $50,000, which is not the case because you can get those attorneys' fees. And if it's quite egregious, you can get those punitive and compensatory damages. But the damage model on employment law cases particularly sucks. There's really no other way about it. Um, I love talking and helping other lawyers. If you ever need to bounce an idea off me, feel free to reach out to hello@langefirm.com or call me. Um, Also, I'll put in a plug, send me referrals. That helps keep me in business. Because so oftentimes it's hard to find a case, right? A lot of people get terminated for at will reasons, and yeah, but. The idea here is that when your PI client is hurt, be mindful of the rights that they have at work because they don't just have to have their personal injury dealt with. They also need to keep their job, and there really are mechanisms to help them keep their jobs and don't let them down by being um, unknowledgeable about the rights that they have in the workplace. Um, we need to do 11 minutes of questions in order to get CLE credit for this, so. Uh, ask me your questions.
I'll go first since somebody has to go first always. Uh, so the 2008 amendments, I get the point that they were intended to be basically as broad as possible, but is there anything that you've seen in the case law or that exists out there that is maybe just like a bit too far and is not going to be covered? Like, I mean, an example might be something like restless leg syndrome. Is that something that is covered as broad as this is?
Oh yeah, I would imagine restless leg syndrome is covered. Something that's not going to be covered is like I got the flu. Um, I think you could fire somebody over having the flu and not coming in to work. Um, that's probably not going to qualify as a disability. COVID was a weird one. Um, people needed leave. There was all that. Anyways, I won't get into COVID, but it was a weird one. So minor illnesses can sometimes not qualify. But yeah, the rest, if it substantially affects one or more major life activities, it's going to count. And it's very broad.
And since that was so broad, and back then, time frame of the Obama administration and all of that, and that things politically with the current climate are just a little different than they were back then. Is there any effort or anything that you've heard about or anything that you've seen trying to roll that back to make it far less worker friendly?
Well, conservative judicial appointments never help. The EEOC has had a hiring freeze. They've been subject to government shutdowns. They've been through it. They've been through the ringer. And in doing so, they have lost staff. They're underfunded, and they just do the best that they can do with the resources that they have. And so if you are not getting the full manpower of the federal government to pursue the investigations on these cases, uh, whether it's a disability case or a sex discrimination case or whatever it may be, that hurts case value because the more time they're able to pour into cases, the more cause findings they're able to issue, the better that the rights are for workers. But I will say to PI attorneys or any other attorney out there that either has a disability discrimination issue or something in between, like don't try to do the EEOC process yourself. It really was started out to be a help for workers, and then the defense bar got into it, and then they started making so many affirmative defenses based off of not doing the administrative process correctly. And so then what happens is if you don't know what you're doing, then you set yourself up for getting your case dismissed on summary judgment because I mean it's literally as simple as not checking the right box. There are boxes you have to check. And if you don't do it, then yeah, you can um, end up losing out on that case, potentially malpractice. Um, so don't. Now, the state government did talk about completely getting rid of the Human Rights, Civil Rights Division at the Texas Workforce Commission, which is the analog of the Equal Employment Opportunity Commission. So that would have an effect. Yes, not necessarily repealing the law, but um, getting rid of the investigatory agency. And so then if you have a law that people can't enforce, then it's really just a paper tiger and you don't have a law at all. So. I know y'all got more questions from the audience.
I'll give you one more to work on while everybody else types their
Okay.
questions into the Q&A box or chat or whatever that is. What is your absolute favorite part of practicing in this area? Like what gets you out of bed? Like for example, in my practice area, my favorite part is when we actually get to trial and I actually get to just tell our side of the story. So like that is why I go through all the other stuff, all the petty little discovery fights, all that kind of stuff, because I finally get to tell, what our side of the story is. So what is your like one reason that gets you out of bed for this practice area?
I like helping people. I mean, this is real pain that people go through. Your job is often part of your identity. Um, People don't always just get fired. They're still employed and they're dealing with a terrible situation. Um, they're dealing with law that's stacked against them, and being able to step in and say, hey, we're gonna do something about this. That I enjoy doing that. I really enjoy the attorney is one thing, and employment law is a challenge. It's not it's a complex area of law. Um, and but a lot of it is being a counselor at law. So the attorney part's great, but the counselor part is what I really enjoy doing, which is, helping people get through this stuff. And then of course I always like having happy clients, which I think everybody likes that when people are satisfied with the result. Um, yeah, that's good. Um, I'll start talking about other areas of discrimination if people don't ask me questions. Oh, okay. I'll start talking about sex discrimination then. So, um, there's two laws that don't have that 15 employer threshold. One is the sexual harassment law. They changed it in 2023. And they brought down the threshold of one employee. So, it is important now for everybody. You can't really hide behind the 15 employee rule for that. And sexual harassment cases can be significantly bad depending on the level of harassment that somebody's faced. So it's important to have employee handbooks and things like that because it's an affirmative defense that if you have a handbook, have a way to address uh, the discrimination and the employee fails to follow the handbook or the procedure, you can end up getting out of that on summary judgment as an employer. Um, and then there's race discrimination under it's called the KKK Act. It's 42 USC 1981. I always get it confused with 1981 and 83. But that's race discrimination in contracting, and the law was applied that an employment relationship is a contract, and that goes down to one person. So if somebody's being racist in a small um, office, then you can move forward under that one. And that one has a 4-year statute of limitations, unlimited punitive damages, like compensatory damage. It's a good I like the law. It's better than the other ones. But the same goes for disability discrimination and all those other laws is that you have it's a thought crime. You have to show that what they were thinking was a motivating factor in terminating the employee. And that is oftentimes really hard. You have to use circumstantial evidence because they're not just going to say, when are you going to retire? Which is not a legal question to ask somebody over the age of 40. Um, and Sometimes that happens, and that's great for the case when that happens. But by and large, it's this subtle, oh, you got injured. Next thing you know, your performance reviews are bad. Start getting written up. Work starts getting taken off your plate, and that temporal proximity just happens. Or somebody lets their employer know that they have cancer, and then they do a layoff of 20 people, but 5 positions are open and aren't going to get filled. 5 positions get moved to a different part of the company, and 4 positions have people retiring and aren't going to be filled. And then one person gets a pink slip. Then that's like, okay, well, you didn't have to say that the guy had cancer, whatever it is, but you made this, you went out of your way to make this reduction in force of 20 people, and it was really only a way to get rid of one person. So there's that is a uniquely challenging part about employment laws. You don't normally get um, that direct evidence. Sometimes you do. Sometimes people are stupid enough to put it in text messages, racist stuff, and those are fun. But doesn't normally happen. Any more questions, Daniel?
Last question. If somebody was interested in transitioning into this area of law, besides emailing, calling you, are there any like blogs, other kind of, networking groups? Where would be the best place for somebody to start if they were thinking about trying to practice in this area?
Um, I would encourage people to call me first. I really do like mentoring people, trying to figure out why they want to do employment law. And then there are two organizations. There's the National NELA.org, National Employment Lawyers Association, and then there's TILA, TELA, at mytila.org, and that's the state version. And then there's Houston TILA, and there's also Dallas TILA. That's the respective chapters of TILA in those cities, and that's just a good networking place to do. And it's not just discrimination in employment law. There's plenty of wage stuff too, to be done where people aren't getting paid correctly. So it's not just discrimination. There's plenty plenty of different variety of work to do in the employment law sphere, and that's not even counting labor law, which is also very interesting to get the National Labor Relations Act and the Labor Board involved. Um, they're like a mad dog; they'll bite and they won't let go. So I think that's all I've got.
Awesome. Well, we really appreciate the time that you spent here with us today. I know that I definitely learned a lot. This was a fantastic presentation, as always. We're always so grateful how much time you give to both HYLA and HYLIF. I think the last presentation you gave before this one was the Bostock one. Does that sound about right?
Yeah, that one's all outdated now. It's all now they've no wait, no, that's not outdated. That's I can't remember, but it's definite now in law that sexual orientation and gender identity is a protected um status under the law. I do think that was Bostock.
Yep. Yeah, and that was another one of your fantastic presentations. I think we have a bunch of them hopefully still up on the HYLA YouTube channel or HYLIF YouTube channel. But yeah, I just want to say thank you again. We really do appreciate how much time you spend with us, educating us on important topics, stuff we all need to know about.
Yeah.
And uh, yeah,
Yeah.
any parting words you want to leave everybody with?
No, I mean, feel free to pick my brain, call me. Also, another thing that I've helped personal injury attorneys with is probate issues when they like need to know who in a wrongful death suit is the right client to sign up. I've counseled people on that before. And again, that's something that I'm happy to talk to people about because you definitely want to sign up the right client.
Absolutely, and that is really helpful to know that's a specific thing. Just when we're out in the high lift community networking, of just we have a person for that now that we can send them in your direction.
Absolutely. And if I don't do it, I probably know somebody who does, so don't be shy.
Awesome. Well, yeah, for everybody who is still on the line with us, thank you so much for joining us. We have another bunch of high lift CLEs coming out of our committee over the next couple of months. Check the HYLF calendar for them. We hope to see you at some of the next CLEs and hope you all have a great rest of the day. Thank you so much for joining us for an hour today.
Bye, y'all.